The networking this evening is great. I really appreciate all the conversation that's going on. Glad to see new people out this evening. How many of you, this is your first time? That's great. It's always good to see new people. So, did you guys hear about the Japanese probe to the asteroid that landed 2 rovers on the asteroid? How many of you have heard about that? So this is one of the first times that we actually have serious analysis of what an asteroid actually consists of. If you haven't seen the photos, it looks like a big pile of gravel.
With a big bright light.
With a big bright light, yes. The other news, this was from yesterday. Do you all remember the New Horizons space probe that flew by Pluto a couple of years ago? So they announced yesterday that they had made a course correction burn, and it is now squarely on target to pass by a Kuiper Belt object next year. So that's just an amazing development as well. Gotta get my clicker. So we have a couple of really interesting announcements this evening. It would help if my thing was working here. There we go. So about a year ago, we had a presentation from, and now I'm forgetting his name. We had a presentation from a company called NewSpace, and they are dedicated to democratization of space. They are developing some offerings to help space startups around the globe, actually. And in the intervening time, NewSpace Chicago has been negotiating with them to develop a program here at MHub. And so today, we are very happy to announce that this program has been signed off on and is now available. So the offering is threefold. It comes in 3 parts. NewSpace is providing a crowdfunding platform for space startups. So this gives you a way of raising money for your project. They have an online courseware program that is designed to help you build your space company, and they also have other content which is related to that, including like TEDx style talks and so forth. And the third part is actual physical incubator locations around the globe. And so NewSpace Chicago, in conjunction with MHub, is happy to announce the creation of MHub Habitat, which is, we have a pod of 6 dedicated reserve desks here that are specifically for the Orbit Muse program. And so MHub will be the facilities manager, and NewSpace Chicago is the community manager. And so we will be providing content from Orbit Muse and helping new companies get started here in the space. So we're really excited about this. We look forward to having more companies that are focused on space here at MHub, and really to help build that community. So we expect to be hearing more about this in the coming days and weeks. The second announcement is the NASA Space Apps Challenge. So this is a yearly hackathon sponsored by NASA. It's basically a global event, and there are specific locations around the world where people come together to participate in this hackathon. And NewSpace Chicago, in conjunction with DePaul University, will be hosting the Chicago iteration of this event. And so the hackathon is focused on Earth and environmental science with support from NASA, and so we expect NASA will announce the specific details of the challenge at the beginning of the event, and it's a 48-hour event. People come together to develop solutions for that particular challenge. This is being hosted at Launchpad Labs, which is over on River North on Huron. So that is happening in about 3 weeks. It was up there October 19th, 20th, and 21st. So we look forward to having a great event with that. Finally, I would like to give a shout out to our sponsors. MHub, of course, is providing this wonderful space for us to have these events, and also Metropolitan Brewing is a local craft brewery, and they are sponsoring the delicious beverages that you all have been enjoying this evening. So, our speaker this evening is Charles Mudd, and he will be speaking to us about space law and how it applies to space startups. This is the second in a series about space law, and we expect to have some additional iterations of that down the line as well. So, without further ado, I'd like to introduce Charles Mudd.
Good evening. As Dave introduced me, I'm Charles Mudd. I'm an attorney here in Chicago with Mudd Law. We have offices in Chicago as our main office, and Park City, and most recently opening in Houston. You want me to do that? So my presentation tonight originally was going to be just startups and space law, or space law and startups, but I just came back just a couple weeks ago from the United Nations' first conference on space law and policy held in Moscow, and I want to talk about that and kind of give a recap of the events that took place. It was really fascinating from both a policy and a legal perspective. A lot of interesting people there. And it's something that the United Nations started over the last few years. They had workshops on space law and policy on different items, different topics rather. And this particular year was the first conference bringing about 180 selected individuals to discuss space law and policy. There were some speakers, obviously they're not seated there at the moment, but there were some speakers, but definitely a lot of discussion between the delegates that were at the conference. One of the things that I found interesting is I go to a lot of legal conferences. I'm on the board of the International Technology Law Association, and there are a lot of lawyers at those conferences. But this conference really, there were lawyers to be sure, and law professors, but more than that, there were really a lot of policymakers from all over the world. In fact, some places that I had not met colleagues at before. So the United Nations conference was hosted basically by UNOOSA, the Office for Outer Space Affairs, and I highly recommend their website. It's a great resource for just what's happening at an international scale with respect to space law and policy. And I hope that you see through the presentation of what happened at the conference and tying it into just talking about space law for any space startup or company, the relevance of what is going on through the United Nations right now. As I was mentioning to some people earlier, the other interesting thing that I noticed or that I learned, I guess it's not surprising, is that there's the United States, there's Russia, they don't necessarily always get along, and then there's everybody else. And that basically was kind of what was going on. There was a lot of interesting propaganda, I guess, from the Russian side because it was their home turf. But I was really actually impressed by what ROSCOSMOS does and its initiatives in terms of space law and policy. So it was in Moscow, and it was also, as I mentioned, co-organized by the Russian Federation. And I do want to say that the Russian individuals from ROSCOSMOS and their various departments were quite hospitable and really great to work with. So there were a number of diverse topics addressed that we talked about. Promoting the responsible, peaceful use of outer space. I think that was one of the key things. You know, when we talk about, or we hear our administration talking about the Space Force and launching a new branch of the military, it does cause some concern for other countries and kind of heightens some escalation with respect to Russia. But Russia's already been doing that, and the United States has already been using or talking about and developing aspects of space technology from a military perspective. They just are doing so through the Air Force rather than having a Space Force. But anyway, that was one of the primary topics. Legal aspects of space debris mitigation and remediation. One of the interesting things that I think I alluded to a little or talked a little bit more about further is the amount of space debris and objects out there, and the fact that there really is no international consensus on what should be disclosed as orbiting our Earth, and different countries have different selective mechanisms to determine what they report. Space resources exploration, exploitation, and utilization. This, of course, is the issue of mining asteroids. Dave, you mentioned that they weren't mining, but dropping onto an asteroid to see what's going on. The future aspects of mining resources from those, or mining resources from the moon or elsewhere. It is a hot topic, and from the legal and policy side on an international scale, it's relevant in terms of does that violate the Outer Space Treaty, where treaties where basically nobody owns the moon, nobody owns extraterrestrial objects. But the question is, can somebody privately, can a country or something own the items that are extracted from those resources? Space traffic management is part of global governance. The space traffic management, as more and more items go up into space and there's more commercial activity, has become a significant issue. And then capacity building in space law and policy is generally, what that means is, from their perspective, it's building resources and mechanisms to enhance awareness and get to the point where not only the international community but national states and the private sector come together to build a consensus on a lot of these issues. As I mentioned, there were panels, really diverse and substantive panels, with a quite diverse selection of individuals. And the report from the workshop, that was another, from a poli-sci background, another part of it that was really interesting to me was after 2 days of presentations and discussions throughout the day, the last day in the morning was basically everybody coming together and deciding on what the conclusions were from the conference. And that was, there were about 44 paragraphs, and there was a debate among countries. I was sitting in front of the representative from the U.S. Department of State, who he and a colleague from another country had some objections to the language of the proposal that had been submitted, but it was basically working through that until it was 1 o'clock, and they said we had to go to take the tour of the Cosmonaut Center. So then they sent the remaining paragraphs by email, getting solicitations. I'm going to talk about some of the paragraphs because it does come back to relating to the private sector and the commercial space sector in terms of what may be coming down the line internationally and then actually nationally in the United States. But some of the highlights were talking about the concerns with increase in actors, such as the private sector, prevent the militarization of space, which I think is a concern for everybody, that nothing is used in space, not putting things on the moon or satellites or other things with missiles and so forth, is really keeping space demilitarized. Cybersecurity was a huge issue, and that should be an issue that any startup is concerned about, that cybersecurity and data security, as you'll see in a little bit. And then finally, the Space 2030 agenda on that page, space debris, talking about space resources, comparing Outer Space Treaty and the Moon Agreement, and space traffic management again. Now, I mentioned earlier the different countries having their different perspective on what to register, when to register it, and so forth. The ideal is that any country that launches any vehicle in space registers it, so that there's an international database of everything that is out there. We know where it is, what's going on. Likewise, although you can't necessarily register every piece of debris, but if there is a mishap, if there is something that occurs to where debris spreads out, keeping track of that as well. So this is one on the UN's website, the Space Object Register, and that's a link to go and see what some countries have chosen to register. Here's an example of basically complying with that, and I don't know, you probably, doesn't look like you can really read the wording that well, but it basically says exactly where the position is, what the object happens to be, and a lot of information about it. So those are the kind of reports that would be submitted ideally, but as many people indicated there, the United States is very selective on what it chooses to say that it's launched. So, for example, reconnaissance satellites, it's not going to necessarily disclose all that much. With respect to space traffic management in particular, the concern happens to be that as commercial space, as the private sector grows, that there is going to be needing a policy perspective or a mechanism to manage traffic. There's a lot of debate among the individual countries that were there as to whether that's more a national or should be an international effort. But given the number of objects, the actors, I mean, for example, SpaceX's proposal to launch, the set of satellites to provide broadband service and so forth. I think it's something like 400 plus satellites. I'm sorry?
4,000.
4,000, sorry, I missed that extra zero. So that's just an example of the significant increase in objects going up into space. Eventually the space tourism, we have our first space tourists announced, and of course I just was talking about the large constellation of small satellites with SpaceX. All of these really come to focus and are really a significant need to be, or a significant issue to be addressed. The comments from some of the people there were that UNOOSA and COPUS were good organizations to address this, and likewise the International Civil Aviation Organization and the International Telecommunications Union. Overall, it was great, but if I had to take one takeaway generally, it's the focus on cooperation. And it was a leading theme of the conference, and although I'm bookending my kind of recap of the conference, one of the things that really highlighted that for me, or kind of the theme that they introduced the conference with, was Thomas Stafford, who's the oldest gentleman in the photo, and he was the astronaut that was on the Apollo-Soyuz, one of the astronauts on the Apollo-Soyuz mission, where the United States and Russian connected in space, and then met, worked around, and then eventually disconnected from one another. So that was how we started, kind of after some preliminary speeches by people. That's how we started in having a video and him presented with an award. And I really think it's definitely focused on the theme of cooperation internationally on trying to resolve these issues so that the use of outer space is safe for everyone. Now, with that being said, I'm going to move into, and that's the first conference. They are planning a second conference, and so those dialogues will continue. The second part of my segment is going to talk about some of the legal issues that a space startup would need to know about. And to a certain extent, the beginning part of it, I'm going to try to go through just some general legal topics that any startup is going to need to know about, and then lead into more space specific in terms of the regulatory agencies and so forth. Unfortunately, this is not going to be a graduate class on space law so that you all can leave here and know everything that you need to know, not that you learn everything you need to know in graduate school or law school, but it's certainly not going to give you all of the answers. But if anything, I hope that it gives you some direction on some of the considerations and things to be thinking about. And that's the most important part of it, because there are any number of startup clients, business clients that I've had over the years that have come to me after decisions have already been made, and it's difficult to walk those back in terms of, for example, trademarks and intellectual property. And so it's always fresh or good to start with those in the beginning. The caveat, of course, is that none of this is to be treated as legal advice. You need an engagement letter from me to actually have me give you specific legal advice. I have to say that. I don't have to say that, but I do say that. So, intellectual property. I started with intellectual property. If you have any questions as we go along, feel free to ask them or leave them for the end as well, and then I'll be happy to talk afterwards. Intellectual property, in my mind, is really where any startup, any business needs to think about, because whenever you have an idea, whenever you start a business, the genesis of that is the idea of the business, and that's when you start thinking about what you want to do. And at that time, or shortly thereafter, is when you start needing to be thinking about how do you protect that information. So there are four primary parts of intellectual property. I don't know if I'm going to read them off in the order that I have them on there, but I think I can remember. It's trade secrets, patents, copyrights, and trademarks. Those are really the four primary categories of intellectual property, or IP. I'm going to talk briefly about each. Trade secrets are basically anything that's not public, that you don't want to disclose to anybody else, and that if somebody else did get their hands on, they're going to have an economic advantage over you, or basically minimize the economic advantage that you have with that information. So, classic example is the formula for Coca-Cola. That is a trade secret that is protected behind, if you go to the Coca-Cola Museum, where I forget where it is, I think it's in Atlanta. It's behind like a huge bank vault, and that's protected trade secret, because that's that's the primary asset of Coca-Cola. If somebody like Pepsi or somebody else were to attain that, then they'd be able to duplicate it, because a trade secret is not a patent, and trade secret is intellectual property or a secret only so long as it does remain a secret. And once it does become known, then the cat's out of the bag, so to speak. So a trade secret can be a trade secret and then become public knowledge, and then it's no longer a trade secret. There's no formal mechanism to register or to protect trade secrets with any government organization. Rather, you have to use non-disclosure agreements. And the non-disclosure agreements are basically agreements that you'd have with an individual that I'm going to give you some information that's going to be confidential and trade secret, proprietary, and you describe the types of information and have that individual agree that they're never going to disclose it. Now, the caution when you're going to an investor, though, or when you're looking to get seed money at the very beginning, is most investors, most angel investors, are going to be turned off if you say, here's my non-disclosure agreement, please sign that before I tell you anything about my product or my service. They're going to probably walk out the door. And the reason for that is there's a practical reason, and then there are any number of reasons. The practical reason is, and this is done the same in the film industry as well, is that if you have somebody sign a non-disclosure agreement, and it's your non-disclosure agreement, you're probably not going to have language in there that's going to protect the investor. And the investor is going to say that, look, I'm getting pitches from any number of people, and I can't tell whether your idea is the same idea that the guy 1 week ago gave me. And so I'm not going to sign the documents that's going to restrict me from being able to use something that I might already have learned from somebody else. That's the practical side, one practical side from the investor, and that is just simply that they may not remember, they may not know, they're not going to restrict themselves on that. There are also legal reasons why they wouldn't want to do that. They wouldn't want to jeopardize themselves, and you're going to probably have a stricter non-disclosure agreement than they are going to have. But in fact, most of the time when investors, or let's say the film industry, or even in some other industries, basically any industry, hands you a non-disclosure agreement, it's going to actually have a carve-out that, yeah, we'll agree not to disclose your trade secrets, except if it's public information, as we said, then it's not a trade secret. Or if we've learned about it from somebody else, some other time, in some other way. And they're never going to tell you whether or not they've actually learned that from somebody else or not. But that would be in their typical agreement. The other reason is that it's just going to turn somebody off, and that's not the way to start a conversation when you're looking for funding. Rather, what the startup needs to do is to learn actually how, or the entrepreneur is to learn what information that they can disclose about the business idea that's not going to disclose trade secrets, to sell the store, sell the whole idea away, or give everything away. But you've got to mince that out. You've got to know what you can disclose while protecting your IP. Patents, the difference between a patent, generally speaking, and a trade secret, is that trade secret, you're never reporting with a government agency. You want to keep it secret. Patents, on the other hand, for the predominant part, are public documents that you record with the United States Patent and Trademark Office. So it's something completely different. You're actually disclosing that information and submitting it to the USPTO. There are some circumstances where certain documents can be filed under seal, but generally speaking, they're public. The other thing, two things to keep in mind on this kind of quick overview is that patent attorneys have to have a science background. So you can have any degree to be an attorney, but to do patent work, to prosecute patents, which is basically to file patents, you need to be licensed by the patent bar, and you need a science degree to be able to do that. So you want to make sure that the attorney that you're talking to either has a science degree or has a colleague that they work with that do patents. I am not an expert on patents because I do not have a science degree, but I do have colleagues that I work with that do patents. But two of the things that you need to know is that you have 1 year to file from the date that you make it public. So if you disclose something, let's say you do a research paper and you disclose the technology in a research paper, if it's publicly disclosed, you have a year to file your patent or you lose all rights to it. And then also, it's first to file. So if you're actually out there talking about it and you're not filing it, the clock is ticking probably even sooner if it's a really good idea, because if somebody sees that idea and goes and files first, then they would be in line before you. You can search patents at the USPTO.gov site, Patent and Trademark Office, or the better site actually now is patents.google.com. Yes, sir?
Is there more than one kind of patent, and what's the difference between them?
Yeah, there are different types of patents, and there's design patents, mechanical patents, and business method patents was a thing that's really fallen out of favor. The traditional patent is, it's like having a widget. It's a way that a particular product works, and it's a mechanical patent that you would that describes the way that it works, the functionality, and everything. A business method patent, what they were trying to do is certain ways of doing business they would want to patent. And for a while, those were basically being granted, but then they no longer are. But as far as beyond that overview, I'm not the one really to answer that question. But the way that the USPTO looks at patents has changed over the years, and recently they went through a number of amendments, probably about 3 or 4 years ago, that changed a lot of the mechanisms. Copyrights. Just basically, very quickly, the gist of the copyright, I use the classic example. I don't know if you all remember watching John Lovett's Be Picasso on Saturday Night Live, but he would just take a napkin and make a scribble and say, I'm Picasso, and meaning that the napkin was suddenly worth $1 million just because he did whatever he wanted to do on it. And that is the example that I use for copyrights. As soon as you create something that's in tangible form, if you write it down, if you scribble or anything, you have a copyright in that. That's under existing law now. It's not the way that the law used to be. But that being said, even though you have a copyright to do anything with it, to enforce it, you have to register it. And registering a copyright is probably the least expensive of the registrations. The filing fee is less than about $50. Your attorney shouldn't charge significantly more than that. Patents can be thousands and thousands of dollars. And then trademarks the filing fee is like $225 to $325, depending. So it's kind of the middle ground. And the reason that I mention and focus on trademarks here, again, it's the first to file wins. But if you're already using it, you can still use it. So the classic example is there was a McDonald's somewhere, I forget exactly, that had a McDonald's selling burgers, but it was not the McDonald's, and the corporate McDonald's, the whole story there, came in and obtained the trademark. They could prevent anybody else from using the trademark at that point in time anywhere in the United States. But the guy that was using McDonald's before the corporation filed for the trademark can continue to use the mark in that geographic location. But it's still better to be the first to file, and you do that through the USPTO. So going back, talking about a startup, when you think about your idea, you need to determine, is this something new? Is this a new product? Is there a new way of manufacturing a product? That might be a patent, so you'd want to talk to a patent attorney. If you have a great idea for the business name, you want to do your search for the business name before you start investing a lot in signage, creating the company name, registering it with a particular state, because you might find that even though somebody in Illinois doesn't have that name, somebody in California might, and there may be a trademark registered already. It's very easy to go and search for whether or not they're at the USPTO site for trademarks. So do your due diligence. I'd search that site. I'd search Google to see if anybody's using the name. I'd search domain names, go into GoDaddy, although GoDaddy doesn't have all of the domains, the top level domains, so you might want to go to 101 Domain and others to do your due diligence to see if anybody's using the name that you've come up with. And then if you find something that is good and that nobody's using, then grab everything. The .com is the most valuable, and if you get the trademark, if you get a federally registered trademark, you can preclude anybody from getting a domain with your trademark in it, and there's a way to do that by registering it with the Trademark Clearinghouse, so you actually get an email notice if somebody applies for any mark using your trademark. And then grab all the social media. Returning to trade secrets, some of your initial key moments will be with team members. So you do want to get NDAs with your team members, employment agreements, non-compete agreements, and investors. Again, be wary about the disclosure and submitting that NDA in the first meeting, but there will be a time where you will want to and actually have signed an NDA, a non-disclosure agreement. The employment side, just something to keep in mind, that there's a difference between an employee and an independent contractor. generally speaking, if you are directing what that individual is doing and how they need to do it and when they're supposed to be working for you, that is an employee. An independent contractor is somebody that you hire, for example, to mow your lawn, that you want it to be sometime during the week, but you're not out there telling them whether to do a diagonal or horizontal line or exactly how to do the weeding. So the key distinction there, without getting into more details right now, is if you are directing how and when the individual is doing the work for you, that is an employee. If you are hiring somebody to do something that they are trained to do and you have no other direction beyond that, they're an independent contractor. And the difference can be significant if you choose the wrong approach. If you are treating people as independent contractors that happen to be employees and that goes on for a bit of time, the IRS is going to come back and you're going to owe all the back taxes that you would have been having to pay for those employees. And that would have been their taxes, perhaps, and then the employment share, because you would have been required to do the withholding with them. So it can be a significant, and in fact, I had a client that came to me after having made that decision, after a few years had passed, and the penalties and the taxes were in the millions of dollars for that particular business. Enforceability of non-compete agreement. You can't restrict somebody from not getting a job in the same business sector for 5 years. A non-compete agreement that tries to get somebody with a 5-year, it's not going to be enforceable. 2 years is pushing the very limit of it. And I tell my clients that. There's one client that I have that wants to push that outer boundary, so right at 2 years. My recommendation usually is a year. And then you also need to think about geographic scope. I had, and it can be different. I mean, there's a difference between, for example, many years ago, I had a client that was in the hair salon industry, and he didn't want anybody to work in the city of Chicago that had worked with him, and that was overbroad because, I mean, how many hair salons are there in the city of Chicago? Maybe you can block it off in a certain section or neighborhood, whereas if you're a space startup, it very could well be that you don't want somebody to go into the same business and compete with you within the city of Chicago. That might be more reasonable than the hair salon example. But those are the enforceability and non-compete agreements are looking at the temporal limits, which can't really exceed 2 years. Really 1 year is safe. And actually there was a case that came down, I disagree with it, but it is good law. There's a case that came down in Illinois that has said that actually for even that, even a 1 year or any non-compete agreement to be enforceable, that the employee has to have worked for you for a certain amount of time, which doesn't make sense to me to a certain extent. I mean, on one hand, you could argue that, yeah, the employee has to be there a certain amount of time, invest certain consideration, and acquire certain knowledge from you. But at the same time, if they have to work there for 2 years to enforce a 1 year non-compete agreement, then they can leave after the 1 year and do whatever they want. So it's somewhat up in the air. The scope of the non-disclosure agreement is just making sure that it's reasonable, that you can't restrict things that are not trade secrets. And the other thing is that you need to actually treat them like trade secrets. If you are having a document that has all of your trade secrets on it and you have it out on a desk where anybody walking through MHub can see it, that is not a trade secret. A trade secret is where you have non-disclosure agreements that only certain people have access to the information on a need-to-know basis, that it's password protected. Those are kind of mechanisms that you would need to have to be able to enforce a non-disclosure agreement, so that if it ever went to litigation, we would have to defend you, or we'd have to demonstrate those efforts to protect that information. Taxes and employment I kind of mentioned, pay your taxes, know your location. If you have an employee in Utah, you can't just be registered with the Illinois Department of Unemployment Security. You actually have to be registered with the state of Utah as well. And so any state that you actually have employees, you are responsible to that state taxing authority as well as the federal government. So, for example, I have an independent contractor that works for me as an attorney in Texas. Why is she an independent contractor? Because she's had like 1 year less experience than me. I can give her clients and I trust her work and I don't have to supervise it or direct her how to do it. She knows what to do and I can just give her the client's work and she's off and running. So that's my argument for her being an independent contractor. Whereas I have a 1 year, maybe in her second year associate in Utah who is an employee, and there's no way that I could treat her as an independent contractor because I'm reviewing everything that she does, I'm supervising her work, and so I'm having to report taxes in Utah for that employee. Yes, sir.
Would you come and consult the same thing? Somebody that, we've hired a couple consultants in our company that, they've got a couple of the contracts and some other
Right.
companies in the space industry, but they have highly specialized talent, and we just can't afford to keep on staff.
Right. And I think that would be, a consultant could be an independent contractor in that circumstance because you're bringing them on for their particular expertise and you're not supervising or telling them how to do their job. I'm guessing that you're asking.
No, we totally are. We're directing their path in almost every step for a desired outcome. That's specific to the project, but again, they're not on site, they're working on other projects.
It goes into a multivariable assessment, but for example, you just mentioned when they're not on site and if they're doing their work on their own time so that they're setting their hours and just getting the work done, those are variables that can go into the balancing factor. I mean, it's a balancing test, so there's no one determinative factor, but you mentioned some variables there that would lead to the argument of independent contractor. And I'm not giving you specific legal advice. So some final things on here. Social media policies, companies should have them, particularly even the CEOs or chairman of the boards should follow those social media policies. Employment policies you should have, and workplace issues. Now, I'm not going to go into ITAR in here. That was the last program. But another thing that you need to know in the space industry and technology sector particularly is if you're hiring people that are not United States citizens, and there are other categories that can fit in, but generally as a rule, if they're not United States citizens and you're sharing technology information, then you really need to be aware of ITAR. You need to be aware of ITAR in here anyway, to know what you can disclose and what you can't disclose. Yes?
One thing I didn't see up there that I've always found really important for employment is basically invention, disclosure, and assignment obligations for your employees.
Yeah, no, I mean, in terms of their capital or their investment in the company, you mean, or?
No,
the assignment of their work product?
If they invent something while they're working for you,
Yeah.
they're obligated to assign.
Right. That's a very good point. And basically what we're talking about is that if you have an employee or even independent contractors that are doing work for you, you want that contract, that employment agreement to have in there specifically that there are a number of different paragraphs, the sections that all lead to the same thing. One is that what they're doing for you is work for hire, so that you basically, as the company, own that product, you own the technology, anything that they create for you during that time. And then there's language in there, if for some reason it was not determined to be a work for hire, they give you a permanent, irrevocable license to use the material and transfer that over to you. So basically, there are mechanisms set up so that however it's interpreted, the work that they're doing for you, you have ownership of. And that can be an issue if you don't have that, because you could, and a lot of this sometimes comes up in the university research context, but if you don't have those provisions, you can find that somebody's doing work for you, and if there's not an employment agreement that says that they are not transferring that over, and there's no restriction on them disclosing, they may go out and start their own business competing with you. So that is a good point that you'd want, or file a patent, right, exactly. So corporation where to file, some choose Delaware, others in the home state. You know, Delaware is very corporate friendly. That's kind of one of their business ways to attract business. It's not necessary that you necessarily need to be in Delaware. The form of entity, will you be looking for investors? What kind of investors? There are all kinds of entities. A C corporation, when you file a corporation created and filed with the IRS, you are starting off as a C corporation. And one of the disadvantages of a C corporation is double taxation. So basically the corporation gets taxed on everything that the corporation brings in and makes. And then any money that it distributes to you as the owner or a partial owner of the company, then you are taxed on that money as well. So the company is getting taxed and you're getting taxed. If it's an S corporation, which is you'd file its Form 2553 with the IRS, you elect to be an S corporation, it's a pass-through then. So basically all of the income, the net profit or net loss that you have with the corporation flows through to your individual tax return and you're only getting taxed once. Partnerships are flow-through organizations as well. Limited liability companies can be treated as a partnership. Limited liability partnerships, L3Cs, I'm not going to even get into that, sole proprietorship. The main thing is to have an entity, regardless of what, I mean, if nothing else, have an entity so that you have the liability protection. There used to be a misnomer that, or thought that limited liability companies, you know, you could never pierce the corporate veil, which means that you could never go through the company to the individual owners on an LLC, and that's not the case. On any particular entity, if there's fraud or somebody's using it as a shell to hide fraudulent conduct, you can get through and pierce the corporate veil. But if you're acting above board, the entity shield will protect. So I mentioned the social media. Don't solicit through social media. He did that too, I think, right, through Facebook, was trying to get investors. Know the regulations. The Jobs Act is a few to several years old now, but it kind of loosens the restrictions on getting investors on crowdfunding, equity crowdfunding. Contracts, get it in writing. You should be aware of GDPR, Privacy Shield, and state regulations. Licenses and permits, just one quick thing. If you have a business in Chicago, you need a license. If you're operating in your apartment with one employee and that's you and you haven't made any money, but you're still operating as a business in the city of Chicago, you need a license. And it's actually a home-based license. But more importantly, you need to know the industry and the regulations. And that's what we're talking about here today, is space-related laws and regulations. So I'm going to try to go through this in a good pace. Have we still got on time? So let's start from the ground up, for lack of a better term. First, I would again emphasize the need to be aware of ITAR and EAR to govern the information you can share with your employees or independent contractors. There are any number of space-related laws and regulations and entities, and in fact, Dave last month mentioned some of the agencies that are at issue. FAA, FCC, and NOAA are a few, but does anybody know what department the FAA is in? Yes. Department of Transportation, correct. The FCC, NOAA. NOAA is Department of Commerce, right. So within the FAA, there exists the Office of Commercial Space Transportation. Now, I'm going to focus on specific aspects of FAA regulations because there are any number of FAA regulations. We're not talking about flying planes. We're not talking about air traffic control here. So the Office of Commercial Space Transportation arose. The enabling statute was the Commercial Space Launch Act of 1984. And so when any lawyer talks about an enabling act, basically that's the act or the statute that created the agency or the department. And in the United States, just to give a very one-sentence overview, the hierarchy of laws are treaty in the United States perspective. So federal law trumps state law in most cases. But there's treaties, and then there's statutes, and then regulations. Those are the three kind of hierarchy. So if we have an international treaty, we should not be enacting statutes in Congress that violate the treaty. Likewise, we shouldn't be implementing regulations that violate a particular statute. So the Act, or the Act of 1984, created the statute, the United States Code, and that's the enabling statute. And then since then, there were actually the Commercial Space Launch Amendments of 2004. The enabling regulations, the governing regulations, so once there's a statute that gives the agency or the department authority to regulate something, then the regulations are created, and that's really the more down and dirty aspects of governing the actual operations. And so the primary for the Office of Commercial Space Transportation and its authority, the regulations are at 14 CFR, or Code of Federal Regulations, Chapter 3, Parts 400 to 600, and 460. And all of this is searchable on the web. I mean, you put in CFR, you're going to come up with the electronic CFR search database. So this particular department, Office of Commercial Space Transportation, so they regulate launch or re-entry vehicles, launch sites, issuing experimental permits for reusable suborbital rockets, and safety approvals. And for example, with launch or re-entry vehicles, the kind of process and everything that's involved is a pre-application consultation with the FAA, policy review and approval, and then a safety review and approval, payload review and determination, financial responsibility, and then an environmental review. And the environmental review kind of cuts across all federal regulations because there was a statute and then implementing regulations, not enabling regulations, but the implementing regulations. A few years ago, there was a statute to make sure that anything that was done with the federal government had to have an environmental impact. So that's where the environmental review comes down, that redounds to even somebody, a private sector company applying. And then after a license is issued, there would be compliance monitoring. Same thing for launch sites, the same kind of mechanism going through all those steps. With respect to launches, there have been 299 total launches since 1989, and for this calendar year, there have been 24, and there are 24 active launch licenses. And this is just kind of the cover page of two of them, one for Orbital Sciences Corporation and one for SpaceX. Issued the one on the left, 2013, and the one on the right, 2018. That department also has experimental permits, and the experimental permits allow, particularly where there's new technology and the re-entry, you can research and develop and test new design concepts, equipment, or operating techniques. And that's a mechanism as you're doing that to show compliance with the later licensing process. The other advantage of experimental permits sometimes is that it's a 120-day review process versus 180 days. But you know, here's an example, and these are all available online as well. But the sample experimental permit, just to give you a sense of the paperwork that's involved in the process, and that's just the formal application. It's a 74-page document, and the actual application is 61 pages. Safety approvals are a really interesting mechanism that's permitted through that department and agency, and basically that allows you to get approval on a particular product, on a particular mechanism, launch vehicle re-entry, safety system process service, or any identified component, qualified and trained personnel performing a process. And what you're enabled to do, rather than go through a separate licensing application for each time, if you get a safety approval, then you don't have to re-license or get approval for that same technology. You can just submit the safety approval. But, of course, you all in the audience might not need your own launch site or your own launch vehicle or re-entry vehicle, and you'd want to use somebody else's payload, SpaceX, or any number of organizations that are setting that up. And one way to coordinate that is to use a consulting company such as Orbital Transports that can help you navigate coordinating with those particular entities. Before leaving the FAA, I just want to mention, related to space, not necessarily outer space, but parts of our atmosphere, the stratosphere, and so forth. Weather balloons, high altitude balloons, and so forth are also all regulated by the FAA. Drones, and so again, these are examples of other regulations that may come into play depending on what your particular technology happens to be. Now, one of the things on the FCC, this is just a little quiz. Section 22.925, prohibition on airborne operation of cellular telephones. Do we think that applies to airplanes, weather balloons, or everything? Yes. Applies to everything. So if you have a cell phone on a weather balloon, you better have the cellular technology shut off. Yes.
What about the first few sets are actually developed from cell phone?
If they were to do anything, they'd have to get a permit or ability to work around this particular regulation, because the regulation does. You can have technology, I know Adler sends up the weather balloons, like my oldest son took a class there and they sent it up with a cell phone to take camera photos and everything like that. But the cellular function of the telephone would have been shut off. It would just be using other functionality. Now there may be radio communication devices in there as well that's sending communications back and forth, like the GPS and so forth.
CDMA or something.
Right, exactly. So the FCC, Federal Communications Commission, is more broadly any communication, and that's our radio signals, AM, FM, amateur radio, anything, but particularly satellite communications is at 47 CFR 25-101. And the FCC is one of the independent, I know somebody said Department of Commerce, but the FCC is actually an independent commission within the government. So it's not actually a department under the control of the executive branch or the president per se, similar to the Federal Trade Commission. So this is an example to the side of a license application that SpaceX filed earlier this year. And so there's licensing and permitting as well. The licensing is more traditionally what you'd wanting to be doing. Now, are you all familiar with the swarm example of what happened earlier this year? So, as I said, the FCC regulates any communications that you're sending. I mean, they don't regulate what you and I are talking about right now, but anything that goes through the air, anything that goes through space, radio waves, what have you, they regulate it. There's some discussion whether they still should be regulating everything, but the point is right now they do. And so to send anything up, satellites or otherwise, that are going to send communications down to the United States here, you need a license from the FCC. So Swarm was a startup from California that created really small satellites, like basically like a book. basically, and they were wanting to send up some small satellites and had filed for a license with the FCC. The FCC denied that application because they were concerned that they were too small to be tracked. Swarm, in its infinite wisdom, said, you know, we are based in the United States, but we don't have to launch from the United States. And so they reached across the waters to India and used a launch company in India to launch their satellites into space. The FCC was none too happy about it. And what's interesting is that Swarm had actually had a permit for another launch later in the year that had been approved. But once the FCC learned what they had done with their smaller satellites, they suspended the approval process. And so there's been a great debate on, one, whether the FCC has the authority then to pull a permit, whether Swarm had the authority to say, well, if the FCC is not going to grant me the license, then I'm going to go elsewhere, or whether the FCC should be the one really regulating this in any case. The regime right now is that the FCC does regulate it, and one would be foolish to try to work around the FCC when it has control over the licensing and the spectrum and so forth. So the lesson to be learned from Swarm is don't piss off the FCC and don't try to work around. I mean, and then there are any number of ITAR issues too about shipping the technology and information and so forth elsewhere. So we've talked about the FAA, the FCC, and on all of these I could dive into really nuanced details, but what I'm trying to get is somewhat of an overview and an indication that if you walk away you have some basis of knowledge of what you should be thinking about. Think about you know, whether or not your particular startup, your particular business, how this fits into the different regulations. If there's any communication from space to terrestrial here, then FCC. Going up, launching any kind of flight, that's the FAA. Now, taking a look at NOAA, which is a part of the Department of Commerce, and there's actually within NOAA, it's the Commercial Remote Sensing Regulatory Affairs. So if you send something up that's looking back down, then you need to be looking at this and talking about getting a license. So no person who's subject to the jurisdiction or control of the United States may operate any private remote sensing space system without a license, and authorize the Secretary of Commerce to license private sector parties to operate private remote sensing space systems. And that's the Enabling Act is the National and Commerce Space Programs Act. And then you need to get licensing with that. So you need to get a license, you need to have an annual audit, and then there's actually quarterly audits as well that need to be completed, and they're not one page. I wish that there was a way to show the multiple page, like have it kind of spread out, but each of these they're not like a 70-page document, but they're not a 1 or 2 page document either. And then circling back even to where we talked again in the beginning, where I said that at the United Nations conference, cybersecurity was a significant issue talked about. It circles back to even now, where within NOAA and these particular regulatory schemes, they want you to have a data protection plan. And that's in any kind of program, really. The United States, through National Institute of Standards and Technology, NIST, they have documents that can help guide businesses on creating data protection plans and setting that up. But within this particular organization, they definitely have a template for a data protection, and it's something that all of us should have into place. And in fact, if you have insurance for against tax and cybersecurity and so forth, I would imagine that the insurance company would want to ensure that you had a data protection plan in place such that you're not just buying the insurance and not doing anything to protect the data. Even within the CRSRA, there's coordination between any number of other agencies. So even though you just have to file the license with NOAA, NOAA then is going to submit a license application to the Department of State, the Department of Defense, the Department of the Interior, the Joint Chiefs of Staff, and the Office of the Director of National Intelligence. And all of those agencies have to give a sign-off on the license application before it's approved. There is a mechanism over here on the memorandum of understanding between those agencies. There is a mechanism to resolve disputes, but nonetheless, the approval through that process needs to be completed. Finally, the winding down a company, we don't want to talk about that necessarily. We don't want to think about that necessarily, but there's an example again when looking at employees. Telltale Games, are any of you familiar with Telltale Games? It's a video game company with about 250 employees, and it announced abruptly that it was shutting down and telling all of its employees that they were out of a job effective immediately. And there's a regulation that requires companies with employees with more than 100 employees to give 60 days notice. And so that oversight has exposed the company, Telltale Games now, as they're going out of business anyway, but with any number of lawsuits from the employees that have lost their jobs. And I'm sure there were any number of attorneys, jumping at the chance, it's not me, but jumping at the chance to file one of those lawsuits. But unless it's a class action suit, I mean, the damages from the actual individual employee, I don't know. I mean, it's only 2 months' time, really, because they'd only need to get 60 days notice. But that little oversight has caused that. And just, again, winding down, you need to have communications with your investors and proper disclosures. So what I tried to do with this, this presentation in the time that I had is to give you an overview on what happened at the United Nations Conference. I think that, from my takeaway, the coordination between the different governments and the push to create some kind of international regulations on any number of those issues that we discussed, that is going to push down to the treaty level. I mean, there's the Moon Agreement out there. We haven't signed that. So I don't know whether we'll sign on to the treaty in the United States or not. But in terms of what the best practices are, it's important for any company, I think, to be aware of what's happening internationally. From the startup law side, I tried to discuss what any space startup should need to know or should know, both from just a general startup perspective in terms of areas of the law, something to trigger ideas and thoughts in your mind, but then to identify some of the regulatory regimes and the licenses that you need to have to be actually do something. For example, to send up a satellite, and if that was a weather satellite, if a company was involved in weather balloons and weather satellites, then they would be discussing with both the FAA, because again, there were regulations regarding the weather balloons, right, outside of the launches and the launch vehicles. So a weather balloon and weather satellite company would be needing to work with the FAA, the FCC and the communications, NOAA on the sensing capabilities, and any number of other things. So I'm happy to take any questions. I hope that it's given you a good overview, and I hope to return as well to target some one of the more maybe niche topics at a later date. So thank you so much. Any questions? Come on. I have to go home and say yes, there were questions.
I'm not sure if this is a great question or not. how does like product liability work in this kind of environment? Like let's say in space tourism, some tourist brings something up into space and it wasn't necessarily built for space, but then gets hurt using it. Is there any kind of liability that, even if it wasn't a space-made product? I would assume if you were selling something to to be used for space, you might have in the contract that it would be hard, space hardened.
Yeah, well, that it is a good question. I would say that any question is a good question. The question is whether it's a difficult question to answer or not. But what's interesting is that was a topic at the United Nations conference too, and it's a topic here in the United States as well. And I think it's a significant issue because it has happened, right? There have been objects colliding into space, and then who's to blame for it? I mean, even so. The head of ROSCOSMOS there was a reception. This is just a quick aside. There was a reception on the second night, and he was hosting that. And he's the one that was accusing the United States of sabotage at the International Space Station because there was an air leak on the on the Russian side of the space, the ISS, and nobody believes that. Nobody up there believed it. But this guy is off spouting these things that it's sabotage. Somebody up there was trying to harm everybody. And so that's just like an aside. And I knew that, but I put on a Facebook post a photo of this guy at the reception and saying, yeah, I'm at a reception and the head of ROSCOSMOS was there. And my sister-in-law, who is from Moscow, told my brother to text me and say, you don't want to mention his name because he is Trump on steroids in terms of the things that he says without any basis at times. And whatever your politics are, I think we can agree that Trump says some wild things sometimes. And so she said that this guy, that he's worse, and everybody in Russia knows it. He's like the laughing stock. And so she really recommended that I remove the name completely from the Facebook post. So I did. But in answer to your question, there is that issue, and where to assign blame. And I think that it goes to a lot of negligence law, so that, if you didn't clear a flight path with the FAA, like let's say a weather balloon, and a weather balloon intersects with a plane or a launch or anything like that, if you don't have the cleared flight path through the FAA, then you're negligent, you're going to be liable for any damage. And then, not only the damage perhaps of the technology going up, but if that technology then falls back on Earth, you're going to be responsible, I would argue, for any harm that takes place here. When that happens up in space, it's going to probably in the end have the same perspective, and the lawyers in the courts will look at it from the same way. And who's doing everything right? I mean, there's sometimes accidents just happen where everything's done right and there's just an accident. And where blame lies, I don't know. The other interesting thing to throw into that is that a lot of governments have immunity from being sued by private actors. So, for example, in the state of Illinois, even there's a municipal tort liability. So you can't sue any municipality for negligence or torts. There are ways to navigate around that, but there are immunities provided to different governments. So let's say it was the government satellite or the government spacecraft that knocked out SpaceX's, constellation of satellites or did something to it. Is SpaceX going to have recourse to the United States? Or if there's an international issue, if it's Russia or somebody else, what are they going to be able to do? Right now, there's no international tribunal to be able to resolve that issue whatsoever. But I think that your question is definitely spot. It is a good question because it was discussed significantly at the UN conference. And as I said, it's discussed among just generally in the legal community here is how those issues are going to be designed. The way to protect from liability is to make sure that you cross the T's and dot the I's and do everything that you can to have the redundancy in place that you can demonstrate in a court of law that there was nothing more that could have been done. We did everything right and something just went wrong. That's the way to protect against getting sued for liability that your product might cause somebody else. And then on the other side, whether somebody else is careless and causes damage to yours, there's no way to control that other than to promote some international way of addressing those issues. Does that answer your question? Any other questions? There was, yes, Jay.
Yeah, I had a question about, in terms of, informing the UN, giving the information on where the satellite is, et cetera. What kind of compliance rate do they have? Do they have any idea? And also, what are they doing to try to make the compliance 100%? You might have just mentioned, but are they purely trying to go at this through human resolutions or overarching treaties, or what kind of mechanism are they envisioning?
Yeah, that's a good question. And the takeaway that I had from the discussion is that there are multiple registers that don't have the same information in them. And so somebody might submit an application or submit a report to one register and not the other. They are broken down in terms of the different technology, but there's some overlap. And so the objective is to try to create some international consensus so that there's one database where people know where to report those things. But I don't foresee the United States or Russia, for that matter, agreeing to a treaty that requires them to report every piece of technology that they launch into space. With the interesting thing, I was at the conference, I was not representing the United States, I was representing myself as a space lawyer and policy advocate. And from a policy perspective, my own personal opinion is that there should be an international mechanism, not only a central database for those things to be reported and everything reported. And there are ways to have things reported under seal and address it. But the high technology, the spy technology, I just don't think we're going to get the U.S. and the Russia to sign off on that. Maybe not even China. But I think there should be a mechanism for that, and there should be a way to enforce it. Maybe it's creative minds need to come up with a way that, but that goes back to the question here on liability too, because the purpose of that is to know where things are, so that you're not going to put something where something else happens to be, because even in space, two objects can't fill the same exact point. And I think that if a country doesn't report something, that they actually have something there, and the space looks clear, and there's a collision or some other thing, then I think that that's something that could have been avoidable. And the concern arises that as more and more objects, more and more technologies put up there, both from the private sector and the public sector, that it's just going to get a significant mess. I don't know if you all have used those star apps, SkyMap or something, but you can set it to show you space debris, right? So you can see the old rocket shells and you can move it around, and the rocket casings that are just floating around. Space is really huge. Somebody came back and also said that we can talk about it here in the United States, we can talk about it on Earth, but when we look around, our perception, we really can't fathom here on Earth the vastness of space, and even in low Earth orbit, how vast that space actually is. And so there was a comment that we really don't need to worry about anything because it's such a huge space. I don't necessarily buy that. Again, I still think that two objects can't be in the same location at the same time, and they can't be on the same orbit with one another because eventually they'll collide. And so I don't know where that's going, but that hopefully will come to some conclusion that benefits us all.
If I can address that just briefly.
Sure.
Right now, it's certainly an issue that there's a lot of orbital debris. But there was an analysis done recently which looked at the advent of these large constellations, like the SpaceX constellation that's going to have 4,000 small satellites in low Earth orbit and so forth. And the conclusion they came to was that the guidelines for deorbiting and end of life will have to be adhered to strictly, so that those satellites don't become orbital debris once they reach end of life. And so that obviously is going to become more and more of an issue as these large constellations start to become deployed.
And so that would mean that as part of the plan initially in putting things up, there would have to be a plan on exactly when those would, the end of life and how that would burn up and everything, and exactly what's going to be disposed of, correct?
That actually is a requirement right now, but the point was that they would have to have a specific plan and adhere to it precisely.
With severe penalties.
Right. Other questions?
Just one quick question. In terms of NOAA and remote sensing, it seems like they're being much more strict than they used to be, and there was sort of a understanding in the past that if it was low fidelity, it wouldn't be a big deal, webcasts, things like that, launch coverage, but they seem to be getting into trouble. I know SpaceX got into trouble recently over their webcast with NOAA. Do you think that they're getting more strict about that, and is there any distinction between resolution?
Well, I'm going to let Dave respond to that more, because his, even before you answered, his response is more vigorous than mine. But I think that, I just say that I think that's a misnomer. But Dave, do you have a comment?
I think they were being lax about the cameras on the launch vehicles, particularly on the second stage. So they cracked down on SpaceX about that, and I suspect there may have been some political issues involved there. But in general, NOAA has been very strict about all imaging systems, to the extent that if you had a camera inside your spacecraft that was taking photos of an experiment and you were not imaging the Earth, you still had to have that license.
And I think that, I mean, what your comment, your question raises, though, is oftentimes there's a misperception on the enforceability or how strict different agencies are enforcing regulations. And it's just oftentimes, I think, because it doesn't hit the radar or it doesn't hit the news necessarily. And that's across the board, not just in space, but any technology, any regulatory environment. But I would then echo what Dave said. So the perception is always to believe that the agency is strictly enforcing the regulations. If there's not a regulation on the book, then that might have an opening. But if there's a regulation that exists, the smartest approach is to always perceive that it's going to be strictly enforced. Because even if it's not strictly enforced, you could be the first one that they choose to strictly enforce the regulation with and be used as an example. And it just doesn't make sense to do that. So my recommendation is always perceive that the regulations will be strictly enforced. Any other questions? Do we have hockey fans here? The Chicago Wolves, right? Or is it the Blackhawks?
The box.
The Blackhawks, yes, but the price of the tickets and the waiting lists are significantly more than the Chicago Bulls. If you have families, I would highly recommend the Chicago Bulls. Anyway, no other questions. Thank you so much. Dave, I turn it back to you.
Thank you, Charles, for the illuminating conversation and discussion about space law. We look forward to the next chapter on this. So I want to thank everyone for coming out this evening. I have two additional things to say. First of all, next month we are going to have a presentation by Brent Abbott, who is the CEO of AAC Microtech ClydeSpace. They are the U.S. branch of the ClydeSpace company, which makes CubeSat components. So he will be here talking about what they do, looking forward to that. And the second thing is that NewSpace Chicago is a volunteer-run organization. None of us are getting paid, but we do appreciate any support that you can give us, and in particular, we are looking for volunteers to help with various aspects of not only running these events, but also some of the other activities that we're doing. So if any of you are excited by the topics that we're talking about and want to support the activities that we're doing, please talk to me or Brendan in the back or Steve here in the front, and we would be happy to accept your help. So with that, thank you for coming out this evening, and please continue the conversation. We're here to encourage the discussion about space and space businesses. So we have the space for about another hour, so please enjoy yourselves. Thank you.